Good morning, everyone, and thank you for joining us. My name is Peter Doughman from Matthews Folbigg Lawyers. With me today, sitting no less than 1.5 metres away, is my colleague Stephen Mullette. Stephen is a partner in Matthews Folbigg's insolvency, restructuring, debt recovery practice, and I'm a senior associate in Matthews Folbigg's employment and workplace practice. It is our great privilege and pleasure to be speaking to you today and delivering our presentation Beyond COVID-19, Critical Legal Issues Every Business Needs to Know. Specifically, I'll be speaking to you today about relevant employment law issues and strategies. And after that, I'll hand over to Stephen, who'll be discussing relevant commercial and corporate law strategies. Before we begin, I just wanted to take this brief opportunity to sincerely wish and hope that everyone out there watching today is staying safe and out of the eye of the eye of the storm with respect to the pandemic. Hello again. I believe we had some technical difficulties, which are hopefully solved. So moving on, to start with the first slide, I will be speaking to you today about a particular employment law issue, and that is specifically the issue arising out of the new JobKeeper legislation, the JobKeeper scheme, of JobKeeper enabling directions and JobKeeper related requests. In the course of preparing for this presentation over the last few days and weeks, I've had the need to answer a great many employment inquiries from employer clients and business clients who've sought urgent advice about the new JobKeeper scheme. And it's become apparent that apart from the big ticket items such as qualifying criteria and registration and the need to pay employees the $1,500 JobKeeper payment every fortnight, a lot of small and medium-sized businesses don't have a great deal of knowledge and haven't had the time or the resources to investigate the rights and obligations they have under the new JobKeeper scheme to issue JobKeeper enabling directions and requests to their staff. Because of this, and because a little bit of information is, in my view, very dangerous, I'll be focusing today on the specific issue of JobKeeper enabling directions and requests. So we can move to the next slide, 2 slides along. Next slide. So I'll start with an introduction. Firstly, as you should all be aware, on the 9th of April, the federal government passed a range of omnibus legislation and measures containing its economic response to the coronavirus pandemic. There's approximately about 20 to 25 different pieces of legislation and declarations and orders, rules and regulations as part of that package. But the main one that's of relevance to employers and employees is in the very sexily titled Coronavirus Economic Response Package Omnibus Measures Number 2 Act 2020. Now, I'm just going to refer to that piece of legislation as the legislation during today's presentation, just for ease of reference, because that's the legislation that contains the entirety of the JobKeeper enabling legislation and the JobKeeper enabling directions. So amongst other things, this legislation does 2 things which I'll be talking to you about. Firstly, it makes temporary amendments to the Fair Work Act, and it authorises certain employers to issue JobKeeper enabling directions and requests to certain eligible employees. Next slide, please. So I'll begin by discussing very briefly the requirements that employers qualify for the JobKeeper scheme and that employees are eligible to receive the benefits of the JobKeeper scheme. Since the deadline for applying for the scheme is tomorrow, hopefully everyone has now looked into these issues or has already applied for JobKeeper, and if they have, hopefully you're already receiving your JobKeeper payments from the government. So I won't take too much time about this, but suffice to say that this particular slide, which you can see on the screen now, sets out the main criteria for a qualifying employer. Specifically, it has to be carrying on a business as at 1 March and be employing 1 or more employees as at 1 March 2020. And it must be able to demonstrate a reduction in GST turnover in accordance with the percentages set out. Now, you'll see I've used the term aggregated turnover. An employer or a business must be able to demonstrate that the amount of turnover or calculate the amount of turnover based on both its turnover and the turnover of any other associated entities within the group of companies or group of businesses in which it finds itself in. So in the case of a small subsidiary company in Australia, unfortunately that company will have to consider the turnover of other parent companies or other subsidiaries overseas, and if that turnover collectively is over $1 billion or $1 billion or more, then to be eligible or qualify for JobKeeper, that employer must demonstrate a 50% reduction to its turnover rather than 30%. To the next slide, you'll see that it sets out very basically the conditions for eligible employees. I won't spend up too much time on that. You'll be able to read them as we go. But keep in mind that employees may cease to become eligible under the scheme. For example, if they receive workers' compensation benefits during the period of a JobKeeper enabling direction, or if they receive paid parental leave, which includes dad and partner pay. If an employee meets all those conditions and accepts the employee's request or proposal to nominate to receive JobKeeper payments on the employee's behalf, then that employee is an eligible employee. So moving on to the next slide, I've set out in hopefully sufficient detail, or in a brief summary form. Sorry, next slide if I may. I've set out the 5 different directions and requests that the new legislation authorises an employer to make or issue to its employees. And see the difference between the directions and the requests. There's a distinct difference between the two, and it's important not to mix these two up, because if you issue a direction to an employee where the legislation only permits a request, or vice versa, you're liable to get into trouble, and there may be claims made against you in respect to those employees. And obviously, given the difficult financial situation all employers find themselves in, that's the last thing you need right now. So starting from the top, the legislation authorises a qualifying employer to issue a JobKeeper enabling stand-down direction to its employees. It authorises an employer to issue a direction to perform alternative duties. And it authorises a qualifying employer to issue a direction to perform alternative duties to those employees. The duties at an alternative place of work. In addition to those three, the legislation also authorises an employer to make a request to employees to perform duties on different days or at different times than what the days and times the employee would normally work, or to issue a request to employees to take paid annual leave. Now, moving to the next slide, I'll start at the top and go through in more detail what a JobKeeper enabling stand-down direction requires. This is a summary of the test that needs to be satisfied. So as I said, the employer, if it qualifies for JobKeeper, may issue an employee with a JobKeeper enabling stand-down direction that the employee may either A, not work on day or days that the employee would normally work or usually work, or B, to work a lesser period or for a reduced number of hours on a day or during a week compared with the employee's ordinary hours of work. And those stand-down directions can only be issued if the employee cannot be usefully employed during the period because of changes to business attributable to the pandemic, or because of government initiatives to slow the transmission of the virus. That obviously is a lot more flexible than the stand-down provisions under the Fair Work Act, which only allow a stand-down to be effected where there's a stoppage of work completely outside the control of the employer. If there's a downturn or employee cannot be usefully employed because of changes to business, for example, you can't afford to pay the employees, then provided the employer is qualifying and provided the employee is eligible, you can issue one of these two stand-down directions. Moving to the next slide, the next direction is a JobKeeper enabling alternative duties direction. And in summary, that allows or authorises an employer to issue an employee with a direction to perform any alternative duties, even if those duties are outside the employee's ordinary duties, provided that the duties are reasonably within the employee's skill and competency, and most of the time that would be fairly easy to satisfy. It stands to reason also that if the employee is required to have certain licenses, qualifications, skills, or training to perform the duties required, that the employee possesses those skills, qualifications, or training. And finally, that the duties are reasonably within the scope of the employer's business operations. So, for example, if your business performs certain duties and functions on a day-to-day basis, you can't direct an employee to perform duties completely outside the scope of what the business would ordinarily perform. Now, moving to the next slide, we'll turn to the third and final duty as a direction available to employers, and that is a duty. That is a right or an authorisation to direct employees to perform duties at an alternative place of work, which may include, but doesn't have to include, the employee's home. Now, again, there are conditions attached to this. The strings attached are that the place that the employee is required to work must be suitable for the employee to perform the duties. And secondly, if the alternative place of work is not the home, that the place does not require the employee to travel an unreasonable distance to reach that location. And when considering that, you'll need to take into account the issues arising relating to the COVID-19 pandemic, obviously including any travel restrictions or restrictions relating to social isolation and proximity to other persons. So those are the three directions that employers are authorised to issue to its employees. There are other conditions attached to that, and in the next slide I'll set out some of those. So in the next slide, these are the conditions. In summary, an employer is only authorised to issue one of the three JobKeeper enabling directions I just specified if, firstly, the direction is safe, having regard to issues including the nature and spread of the COVID-19, and you'll have to have regard to other safety issues as well. Secondly, the purpose of the direction is to reasonably ensure the employee's ongoing employment. Now, this means that if you, as an employer or as a business, have made certain employees redundant or given employees notice of termination due to a downturn in business, then you cannot issue those employees or that employee with a JobKeeper enabling direction during the period of the notice period. If the inevitable outcome is the employee's employment will end, then this condition isn't satisfied and you cannot issue a stand down or other type of direction to those employees. Third condition, and I've summarised a few different types of conditions into this dot point, but essentially the employer must comply with the minimum payment guarantee under the legislation, which is, in effect is to ensure the employees are paid the higher of either the amount payable to the employee for the hours worked by the employees in the relevant pay period, or the amount of $1,500 gross per fortnight, which is obviously the JobKeeper payment. That means that if an employee hasn't been subject to a reduction in hours and would ordinarily receive $2,500 gross per fortnight, you as the employer must pay the employee that amount. If the employee's rate of pay is either below $1,500 gross per fortnight in the ordinary course of work, or that they're subject to a reduction in hours, which causes them to earn on an hourly basis less than $1,500 per fortnight, then you still have to pay them the $1,500 per fortnight. That is the base threshold. And I'll also note that that applies even where an employee is on an unpaid leave. For example, an employee is on on a period of absence due to illness or injury. The employee exhausts their paid leave entitlements and doesn't elect to use any other form of leave, such as annual leave. In that case, the employee would notionally proceed onto unpaid leave, but even in that case, you as the employer still need to pay or meet the minimum payment obligation of paying $1,500 gross per fortnight, even when they normally wouldn't get paid anything. The upside to that, however, is eventually once the payments come through from the government, your net outlay for those employees or that employee will be zero. The next condition, as I mentioned before, the employee must not be receiving paid parental leave, that includes dad and partner pay, or workers' compensation. And for any period that an employee is receiving such payments or another form of government payment, they cease to be an eligible employee for that period, and any directions cannot be issued, and any existing directions do not apply for that period. And finally, as a catch-all, any direction issued as part of a JobKeeper enabling direction cannot be unreasonable in all the circumstances. Now, if we move to the next slide, there's also a requirement to consult with your employees as part of and before issuing a JobKeeper enabling direction. And the legislation provides that such a direction has no effect or does not apply unless the employer firstly gave the employee written notice of the direction, and that notice must be given at least 3 days prior to the direction taking effect or being given, or a shorter period if the employees agree to it. And most of the time I expect the employees will not agree to it. So take as a minimum period obligation that you need to give notice of the direction taking effect 3 days beforehand. I'll also note that the legislation does not specify 3 working days. So technically notice of a direction can be given on a Friday, with it to take effect or be formally given on the Monday. In that case, however, as you'll see, you still need to consult with the employees once the notice has been given, and that consultation will need to be with each individual employee concerned or affected or their representatives before the direction takes effect or is given. The legislation, in my view, doesn't require you to, or doesn't mandate consulting with a representative, for example, the union, if you comply with the obligation to consult with the employees. On my reading, at least, you can consult with one or the other. However, if an employee says, I wish to have the union involved in the consultation, you're obliged or reasonably obliged to comply with that request because it would be a reasonable request. Final condition for consultation is you must keep a written record of the consultation with the employee or the representative and keep that on hand in case it's challenged in the future. Also keep in mind that in relation to the consultation obligation, it doesn't apply in the same way for each successive direction issued. Obviously, the right to issue these directions under the legislation will continue or will be authorised at least until the 28th of September. And it may be necessary for you as the employer to issue more than one JobKeeper enabling direction over time. In such a case, your obligation to consult arises expressly at the time of the first direction, and you're not required to consult at the time of each subsequent direction, provided that when at the time of considering and making the decision to issue the direction, you've had regard to the views expressed by the employee during the previous consultation period. Moving to the next slide, I'll note that the legislation requires that any JobKeeper enabling direction be formally made in writing. It's not sufficient to issue verbal directions only. And when all the other conditions are complied with, which are the subject of the last few slides, that direction will remain in force and effect until one of two things will happen. Either it's revoked by the employer, in other words, a stand-down direction is revoked and all employees are invited to come back to work or directed to come back to work, or where the nature of the previous direction is in effect superseded by a subsequent direction being given. Obviously, that would apply where employees are directed to stand down and then you direct employees to work a reduced hours of work. Obviously, that increase in hours will make redundant the initial direction. And otherwise, if not revoked or replaced, the directions issued will cease to have any effect after 28 September, which is the date that the legislation will automatically repeal itself. Of course, we don't know what the future holds, and so it may be the case that the Australian government, the legislature, decides to extend the operation of the JobKeeper scheme or replace it with some other provision that contains similar rights and obligations of employers to issue such directions. If all those conditions are satisfied, that obviously it must be safe, if it's reasonable, it's not, if you're continuing to pay the employees the minimum payment obligation, and it's not given in the course of or as a consequence of termination, if it's in writing and the consultation requirements are complied with, then if such conditions are complied with, then the employee must comply with the direction. And it's a breach of the Act or the legislation for the employee if he or she refuses to do so. And in that case, obviously, the employer would be entitled to take disciplinary action against the employee or employees if they fail to comply with a validly made and authorised direction. Moving to the next slide. In addition to those directions, as I said earlier, the legislation also authorises employers to make requests of employees. Now, these are not directions, they are requests, and so the employee must not unreasonably refuse to agree to the request, but the employee may refuse to agree to the requests, depending on the circumstances, if those circumstances are reasonable for the employer to do so. So in summary, the two types of requests that employers can make under the legislation, is to request the employees agree to perform duties on different days or at different times compared to what the employee's ordinary hours or days of work happen to be, provided, of course, that the days and times are reasonably within the scope of the employer's enterprise. That means that if your business traditionally trades Monday to Friday, it's unreasonable to request an employee perform work on a different day, such as a Sunday. Secondly, the legislation authorises an employee to request employees take paid annual leave, and that also allows the employer to request an employee take twice the amount of annual leave at half the pay, which is ordinarily not permitted by the National Employment Standards. In relation to the issue of annual leave, just keep in mind that any request to take paid annual leave is expressly required that any request to take paid annual leave does not result in the employee having a balance after the request is complied with of less than 2 weeks. That means that if an employee has 4 weeks of annual leave accrued, the request must be to take no more than 2 weeks, and it stands to reason an employee has less than 2 weeks accrued, you are not authorised to make the request at all. Moving to the next slide, there are some conditions associated with making these requests. Firstly, the request must be safe, having regard to the nature and spread of COVID-19, and that's the same test and requirement as with the directions. And secondly, the request must be made in writing. Now, when those conditions are satisfied, then the employee must consider the request and not unreasonably refuse the request. And one of the obvious questions about unreasonable refusal is when could that arise? And it would depend on the circumstances, but in my view, and as I've advised a few clients over the last few days and weeks, it may arise where an employee wishes to save up his or her annual leave for something at the end of the year, for example, a honeymoon, and doesn't want to use the annual leave during a period that the employee would ordinarily receive JobKeeper payments. So in my view, such a refusal would be reasonable, and where the refusal is reasonable, an employer cannot take disciplinary action against the employee for the refusal. Moving on to the next slide, you'll see that the conditions for issuing those requests are only that it's safe in writing and reasonable, safe and in writing, but on my reading of the legislation, it appears that such a request does not need to be reasonable in all circumstances, and it doesn't need to be given for the purpose of reasonably ensuring the employee's ongoing employment. So you technically could request an employee take annual leave during a period of notice. Of course, an employee would be well within his or her rights to request that, and I would consider that a refusal would be reasonable. And it also appears that the legislation does not require the employer to conduct a formal consultation process before the request is issued or given. Of course, in practice, if you're making a request, that in itself is a form of consultation, so I don't think that has much of a practical effect. But otherwise, you can potentially make an unreasonable request, and you can also make that request during a period of notice if an employee, if you have made a decision not to continue the employment of an employee. Moving to the next slide. I'll finish off by pointing out that the legislation is not all one way. It does allow employees to issue requests, and specifically in the circumstances where the employee is subject to a JobKeeper enabling stand-down direction. That's a direction where an employee not work on on a day or days that the employee would normally work, or to work reduced hours or for reduced days compared to their ordinary days or weeks of work. And when a stand-down direction is issued, an employee is entitled to request to the employer approve the employee undertake reasonable secondary employment or engagement during the period of stand-down, to request to undertake training, or a request to undertake professional development during the period of the stand-down. Now, when it comes to the issue of reasonable secondary employment, my view is that any request where an employee is unpaid for a substantive period of time, any request to work a secondary job would be reasonable unless the proposed secondary employment is with a competitor of your business or where there's some other conflict of interest arising between the work that the employee would do for you generally and the proposed secondary employment. And in that case, when there's a potential breach of a restraint or a restrictive covenant or a breach of conflict of interest obligation, in my view, you could request or you could refuse that request. Otherwise, when such a request is made, the employer must consider and not unreasonably refuse the request. And as I said, there are some circumstances where you as the employer can refuse such a request. Moving to the next slide and finishing off, I just wanted to outline some things to keep in mind when considering to make these directions and issuing these requests. Keep in mind at all times that these directions only apply when an employer qualifies for the JobKeeper scheme. If you don't qualify for the JobKeeper scheme, firstly, my apologies for that. The scheme is not perfect. The legislation is certainly not perfect, and it was, if the government had more time to prepare it, maybe some more businesses would have been captured. But it only applies where the employer qualifies. Secondly, the directions can only be authorised during a period where the employee is entitled to receive JobKeeper payments. And as I said, if an employee proceeds onto a period of paid parental leave and receiving governmental paid parental leave pay or workers' compensation, then the right to issue or the authorisation right ceases to apply. And also keep in mind that a stand-down direction specifically, as opposed to the other forms of directions, do not apply whilst an employee is taking paid or unpaid annual leave or carer's leave, or is otherwise entitled to be absent for any reason, such as working on a public holiday. So in the case of a stand-down direction, to not work a particular week, if a public holiday falls in that particular week, then the employee is entitled to be paid for that day. Moving to the next slide. Other things to keep in mind. Whilst a JobKeeper enabling stand-down direction is in place, or whilst employees are taking annual leave following an authorised request, keep in mind that an employee's service continues unaffected for that period of stand-down or leave. That means that specifically, if an employee has been stood down for a period of time, say an extended period of time over a period of months, or a month or so, and the employee is approaching a work anniversary, that period of stand-down counts to allow the employee's work anniversary to tick over to the next work anniversary. And in the event that you decide to make that employee redundant, that period of service needs to be recognised for calculating the employee's redundancy entitlements and other entitlements, such as annual leave. Also keep in mind that the way that legislation is drafted is it authorises directions to be issued and requests to be made. And the reason they use the term authorised is because these directions and issued are directions and requests are otherwise not allowed under the existing Fair Work Act and the National Employment Standards. So for the period that the legislation is in force until it's repealed, this legislation overrides the existing terms of the Fair Work Act and authorises you to do things that ordinarily you wouldn't be permitted to do. And that also applies irrespective of any contract terms to the contrary in a modern award, enterprise agreement or contract of employment. Despite all of that, keep in mind that the provisions do not override or void the existing employee rights and benefits and remedies under the Fair Work Act, such as unfair dismissal, general protections, anti-bullying legislation, anti-bullying provisions, and redundancy. So, for example, if you are required to make an employee redundant due to a downturn in business, you are still required to consult with the employee and consider alternative redeployment opportunities before making that employee redundant. And if not, it may not be a genuine redundancy for the purpose of the Act, and that employee may have an unfair dismissal claim that he or she may be able to make against you. Finishing up with the last slide before I hand it over. Keep in mind that the JobKeeper legislation will automatically repeal on the 28th September 2020. In other words, the legislation specifically says that all the amendments to the Fair Work Act will be reversed, in effect, on that date. That can only be stopped by a positive act of Parliament, either repealing that repeal section or to extend the operation or extend the period that the JobKeeper provisions and the JobKeeper scheme operates before the provisions are repealed. If that doesn't happen, keep in mind that after the 28th of September, any ongoing JobKeeper enabling directions will cease to have any effect, and essentially employers' rights and obligations and employees' rights and obligations will snap back to those set out in the existing Fair Work Act, which we have all been following in one way or another over the last 19 years or 20 years. In my view, on the basis that there's been a recently announced relaxation of social distancing requirements, the pessimist in me suggests that, or thinks that there's likely going to be a second outbreak or a rise in positive COVID cases over the next few weeks and months, and that may necessitate reintroducing social distancing requirements or other restrictions on work. And so, in my view, it's likely that the JobKeeper scheme may continue or continue in some form or another after 28th September. So the takeaway is watch this space, stay safe, comply with your obligations, and I hope to see you on the other side. Thank you. Now I'll turn to my colleague Stephen, who'll be discussing some employment and commercial related issues.
Thanks, Peter. For my sins, I'm an insolvency lawyer, but in relation to the issues that we're talking about today, I'm going to be focusing on the commercial and corporate law issues that arise out of both what's happening at the moment in the COVID environment, in particular legislative changes that are taking place for the purposes of dealing with the COVID pandemic, but also some other corporate changes that the government has introduced at the same time. So if we can move to the next slide. The point of that is that, in my opinion, these slides will show you, I think, that there is a problem coming that arises in the context of this. Here's a headline from an article in the Fin Review a few days ago, talking about how the banks are already forecasting a huge issue in relation to bad debts. And that's arising out of, in particular, moratoriums that have been given on mortgage repayments, extensions of time for businesses, all of which will come to an end in sort of around about the September-October period. And in addition to that, we all know that there are various sectors, whole sectors of the economy that are affected and that are going to be need to be restructured. And the question arises, well, when some of these moratoriums end, what chance is there of those sorts of businesses in those sectors being refinanced, and who's going to buy them? We'll also see at around about that same time, subject to them being extended, the end of various legislative interventions that have given a bit of breathing space for businesses dealing with their things that we won't talk about necessarily today, landlord occupation rights, leasing concessions, and of course, as Peter has been talking about today, the JobKeeper payments. So if all of that's happening at the same time, then the question arises, what will that mean for us? So I just want to pick on four, in the next slide, we'll pick on four different particular legislative changes that we will focus on today that I think will interact with one another, both during the COVID period and also beyond. First of all, an issue in relation to the recovery of debt, which will affect cash flow. Secondly, a legislative change that increases the directors, the personal liability of directors for company tax. Thirdly, the government's recent changes to avoid creditor defeating dispositions in the context of COVID, that might be relevant, and also an insolvent trading safe harbour, and there's both a pre-COVID and a post-COVID safe harbour to look at. So we'll look at that in our next slide. So first of all, dealing with the cash flow issues, if we go to our next slide, we can see that as part of that omnibus of legislative reforms that Peter was talking about, there are a number of changes. And in the next slide, That particular change was an introduction of an extension of time and an increase in thresholds for creditors to be able to recover their debts. In particular, the issue of, for 6 months, an increase in the level of debt which a creditor must have before they can issue a creditor's statutory demand or a bankruptcy notice, up to $20,000. And in addition, an increase in the time for compliance with those notices and demands from 21 days, as they currently were, up till 6 months. So what that means is you will have creditors who will now not be able to recover by way of a statute demand or a bankruptcy notice any debt less than $20,000. And even if the debt is above $20,000, the creditor will have to allow you, even giving you a notice, 6 months in effect, to pay. So what does that mean for businesses? In our next slide, there are some implications that I think flow from that. And some of them, of course, are positive. The purpose for this regime was to allow businesses breathing space from their creditors so they're not harassed, particularly by smaller creditors looking to wind them up whilst they're trying to work out whether they can or can't survive during this COVID environment. So they will have, if they choose to take advantage of that, effectively time to pay, at least 6 months if they're a debt that's larger than $20,000, or potentially longer if the debt is less and the creditor can't even issue a creditor's statutory demand. Now, of course, it's important to remember that that's not going to prevent a winding up if the demand had already expired, and there are also some negative consequences that flow from that. And I think that is particularly the case for smaller businesses. First of all, it's not going to prevent those debts being due and payable, of course, if you don't pay them, they will continue to increase. It also won't affect whether or not your business is insolvent. That's relevant for things like insolvent trading and those sorts of issues. There are also a bunch of different timing issues, having different notices and different periods, different amounts, and when will they all expire. We had a creditor client who issued 2 statutory demands. One was before, one wasn't able to be served until after, one was enforceable, the other one has to wait 6 months. And the other relevance for directors is that there is, of course, not going to be any concessions in relation to a number of liabilities that directors have, and that's particularly the case in relation to taxes, as we'll see in our next screen. Directors' personal liability for a number of taxes is an important consideration for directors, and that's a matter that directors need to concentrate on. So in our next slide, we'll have the need to consider not only what's going on in their own businesses, but also how that's affecting them personally. So in our next slide, we'll see the change that was recently introduced that's going to increase that scope. Directors should be aware, if you're not already, that you are personally liable for your company's unpaid tax, your unpaid PAYG tax and SGC as well, superannuation guarantee contributions. You have always been liable for those payments since about 1993, but recently, as of 1 April 2020, you are now also personally liable for your company's unpaid GST, in addition, wine equalisation tax and luxury car tax. Now, as I say, that's always been the case for PAYG, SGC. Now it also applies to GST as well. The other significant issue, which has been around for a little bit longer than 1 April, but I don't think a lot of directors are aware of, is that those payments, those obligations that you are personally liable for in relation to your company's tax will become locked down if you haven't been keeping your lodgements up to date, or at least within 3 months of their due date, and on the due date, if it's in relation to superannuation guarantee. That means you cannot get rid of those liabilities. If you have been keeping your lodgements up to date, at least you preserve the opportunity to avoid that personal liability by complying with what's called a director penalty notice that the ATO will issue to you, and which will allow you 21 days to put the company into administration or liquidation. However, if your lodgements haven't been done on time, even though you will still get a notice, it will just tell you you have no choice. You are personally liable. That debt has been locked down. So if you're in the middle of a pandemic and you're dealing with your personal liability for your company's tax obligations, what sort of assistance has the government introduced in relation to that? Well, in our next slide, you'll see that, in fact, the government hasn't actually given any particular assistance for directors. What they've said is that the ATO will tailor solutions for owners or directors of businesses that are currently struggling due to the coronavirus. And that might include delaying or withholding director penalty notices being issued and commencement of winding up proceedings. But what does this mean for directors? Well, we'll see on our next slide. The issue is this. There is a real danger for directors in relying upon that. You have no certainty about any current moratorium or agreement in relation to your personal liability for the ongoing and increasing amounts of tax that your company owes. Secondly, even if the ATO doesn't issue you with a director penalty notice, that doesn't mean that the liability has been removed. And of course, it will continue to accrue if it's not paid, and even worse, it will be locked down. You will be unable to discharge your personal liability for that debt if lodgements aren't kept up to date. So that's a real issue for directors. It's a real issue for their personal exposure in relation to trying to work their way through this COVID environment. And another one is on the next slide, which is the recent introduction by the government of legislation in relation to creditor defeating dispositions. And in our next slide, we'll see the recent legislative changes that the government's made. And that legislative change was in the same legislation that gave personal liability for directors for GST. In our next slide, you will see basically what the government has done is introduce a new avoidable transaction. The legislation was called the Combating Illegal Phoenixing Act, even though illegal phoenixing isn't either referred to in the legislation, nor can anybody define what it is. But the idea of it was to impose a new criminal and civil penalty on directors, and also to allow liquidators to undo a avoidable transaction which involves a creditor defeating disposition. And that's basically this. If you transfer assets as a director for less than the lower of the market value and the best price reasonably obtainable, and that results in or prevents the property or makes it more difficult for the property to become available to your creditors, then you will have committed a creditor defeating disposition. What's the result of that? Well, on our next slide, what we'll see is that that allows a liquidator to undo that transaction. It's void against the liquidator if the transaction was entered into or given effect to when the company was insolvent and within 12 months of the relation back day, basically when the company begins to be wound up. And that's not necessarily the same date as the winding up, but for all intents and purposes, basically when the administration starts. So if that transaction has been entered into or given effect to within that 12-month period, or if the company becomes insolvent because of that transaction, if you transfer a significant asset and that leaves your company insolvent, the same thing applies. Or alternatively, if you enter into a creditor defeating disposition and the company falls over within 12 months, then that transaction will be void against the liquidator. Not only that, the liquidator isn't the only one that can chase you. The ASIC can now issue notices requiring that transaction to be undone. And that's a significant new power that ASIC will have to undo these sorts of transactions. So on our next slide, we'll also see that there's a significant issue for those involved in running these companies. Directors and their officers, there is now a new duty on directors to prevent these types of dispositions, and there's now a new offence, not only for directors or officers, but for anyone procuring, inciting, inducing or encouraging a company to engage in a creditor defeating disposition. And what's the relevance of that? Well, if you're trying to restructure your business in the middle of a global pandemic and you need to dispose of parts of that business, assets that are owned by that business, what is the reasonable price that you can obtain? What is the market value? What is the best price that's reasonably obtainable in the middle of that global pandemic? And how would the director know if he or she is committing an offence under these sections? So that's something that's going to be quite difficult and will play out after the COVID environment is done, as liquidators examine the transactions that directors entered into during this period whilst they tried to save their businesses. So the question is, I suppose, is there any rescue Well, in our next topic we'll talk about safe harbour, and in our next slide we'll see that the government has given some protections, but is it enough for directors? In insolvent trading, first of course, it's important to understand what is insolvent trading, and that's what the safe harbour is intended to protect us against. Insolvent trading is basically where a director incurs a debt at a time when a company is unable to pay its debts as and when they fall due. If that debt remains unpaid at the time the liquidator is appointed, the liquidator can recover that debt from the director personally. That's insolvent trading. However, over recent years, there's been a call, particularly in larger companies which are trying to go through restructures at a time when they're not certain whether they are or aren't insolvent, to call for a general safe harbour for directors trying to work their way through those difficult circumstances. And more recently, in the last month, there's been a further safe harbour introduced in relation to the COVID pandemic. So on our next slide, we'll start with the general safe harbour. And that's a protection that's been introduced basically a couple of years ago that allows for protection against insolvent trading and also against those creditor defeating dispositions that we were looking at before, if those were done as part of a course of action that is reasonably likely to lead to a better outcome for the company. Course of action and reasonably likely to lead to a better outcome for the company. Now, what does that mean? Well, there is an onus that the director bears, and the court will take a number of things into account, including whether the director's been keeping up to date with the company's finances, keeping those financial records up to, in order, and also making sure the employees and officers aren't up to no good. Critically, one of the factors the court will look at is, have the directors been obtaining advice from an appropriately qualified entity who's given sufficient information to provide proper advice in those circumstances? And of course, there has to be an actual plan. Is there an actual restructuring plan that's going to improve the company's financial position? So on our next slide, we'll also see that there are some difficulties. A critical difficulty for directors, particularly in small to medium businesses, is that there are some bars to entry into this safe harbour, and that is that you must be paying all your employee entitlements on time, and you must be lodging all your tax obligations on time. There are some minor exemptions that might be allowed in certain circumstances, and it's important to remember that the lodgement is critical here, not necessarily the payment of that tax. However, for most small businesses, small to medium businesses, the first thing that stops getting done when times get tough and we enter into a global pandemic is you stop doing your returns so that you can work out whether you're going to have enough money to be able to float. This will prevent you from being able to arrive at the safe harbour. However, there is, in the next slide, we'll see that there is a recent addition that the government's introduced in relation to the global pandemic, and that's the ridiculously named 588G-AAA, which is an additional safe harbour for directors in this 6-month period. So it lasts only for 6 months, and it allows you to prevent a liquidator from coming after you as a director for a debt that's incurred during this period if it's incurred in the ordinary course of business during that 6 months. So if you're continuing to trade, even though you might be insolvent at the moment, you may be able to avoid incurring personal liability if the company ultimately falls over, if that debt was incurred in the ordinary course of business. However, the second criteria is that the appointment must be during that period. So that means there's actually, in fact, a drop-dead date for you to appoint an administrator or liquidator if you go ahead and incur that debt during that period. And if you haven't appointed an administrator or liquidator by the end of that 6 months, then it's up to you as to whether or not you'll ultimately be able to persuade a liquidator that that debt was incurred and shouldn't be, the company either wasn't insolvent at the time or you shouldn't be liable for it. So the real questions though are, well, what is the ordinary course of business during COVID-19? What does that look like? And what debts do you need to incur? Is it expending money to set up your employees to work from home? Is it buying new machinery so that you can manufacture a different product because your business is out of work? What is the ordinary course of business during COVID-19? And of course, as I mentioned, you'll need to have made that appointment by that drop dead date, or else the section simply won't apply. So on our next slide, we'll come to some tips. I want to give you a couple of key actions that you can probably take now, and hopefully that'll be of some use to you. On our next slide, first thing, and it sounds fairly obvious, is to monitor cash flow. Obviously, cash is king in the middle of a global pandemic, but you have that opportunity now, given the extensions of time in relation to compliance with statutory demands and the increased thresholds. You have an upside, I suppose you might call it, in that you might have more time to pay, but you need to also remember that those debts are still accruing. Of course, there is the downside as well, and you need to keep an eye on that. Debtors, your debtors, that you need on to rely upon for cash flow, will themselves have more time to pay. So in fact, your cash flow might be made more difficult. So what can you do about that? Well, you can also look at alternative debt recovery strategies for those debts. The only limitations are on issuing creditors' statutory demands and bankruptcy notices. There are lots of other ways to recover debts, and then you can even other ways to wind up debtors if they're recalcitrant. But probably the main point would be both on the debtor and creditor side, look at payment plans on the debtor side to get cash coming in, on the creditor side so that you can obviously keep track of your exposure. Also to assist with being able to demonstrate that you're solvent because you're now entered into a payment plan. You are now able to pay your debts as and when they fall due, and also to avoid insolvent trading. So on our next slide, second tip is to get your finances in order. Again, stating the bleeding obvious, but you need to be on top of solvency, and that's critical, not only just so that you know whether you're trading whilst insolvent, but also that you can make commercial and informed decisions about whether or not, for instance, you want to take advantage of the COVID safe harbour and incur a particular debt, knowing that you've got until that 6 months is up before you just need to decide whether to make an appointment. If possible, you need to ensure, of course, that you keep your lodgements up to date. Now, the lodgements being up to date is not the payment of that debt, but it will at least give you the option of avoiding personal liability for any of that locked down company tax, to avoid that becoming locked down and give you the option to avoid it becoming locked down. Secondly, so that you might be able to take advantage of the general safe harbour if you've got a payment, a restructuring plan that you want to explore. Make sure your lodgements are up to date, and of course you've got to keep your employees paid, otherwise you won't qualify for the general safe harbour. And finally, on our next slide, my last tip is that obviously this is a situation in which you need to get advice. There are a lot of different issues going on at the same time. You need to issue accounting, legal. You might also want to speak to insolvency practitioners or turnaround specialists. It's not as scary as it sounds. They're full of free and useful advice about some of the issues that will be relevant to you and to your businesses in looking to use this as an opportunity to restructure, as a lot of businesses are at the same time. You might want to get advice on a safe harbour protection. If you're looking to rely upon safe harbour, you need advice from an appropriately qualified entity who's given sufficient information. And also, you might want to explore formal or informal workouts, looking at voluntary administration, deeds of company arrangement, and even a holding docker, which is a deed of company arrangement that allows a moratorium for you to explore this period without going into liquidation and come out the other side. Or even if worse comes to worse, liquidation before things get too bad. Lastly, on the next slide, from both Peter and myself, I think we just want to say that we hope that you all stay safe. That's all from me. I'm not sure if we've got time for questions, but Pete, have we had any?
Thank you, Stephen. I'll just see if we've got any inquiries through. I know that we've just hit 12 o'clock. I know that although we started a bit late, we may have just time for one question. Even though I might not get to everyone's questions now, we should have access to contact details. So anyone who has a question that I can't get to now, I'm happy to, either Stephen or I are happy to give you a call, answer the question and chat about any other issues that may be arising relating to COVID or the issues discussed, or anything else that might be, any other issues that might be arising for your business. But I do see that we have got a question that's a reasonably quick one to answer, so I'll deal with that now. That is, we have an employee who has been on a substantial period of unpaid leave due to illness. Does the JobKeeper scheme require us to pay anything to that employee? And so the short answer to that question is yes, you do, because the way the JobKeeper rules and the minimum payment guarantee obligation is drafted. Even if an employee is on paid or unpaid leave, if they've been stood down or if they've been rehired after a redundancy, as long as they're employed as of 1 March 2020 and meet the other criteria and conditions, you must pay each one of your qualifying or eligible employees the amount that the employee would otherwise receive or be entitled to receive for the pay period, or $1,500 gross per fortnight. So in the case of an employee who would be notionally on unpaid leave, you have to pay them the minimum of those two, which would be the $1,500 gross per fortnight. And obviously, when you pay that and you eventually get repaid that amount through the JobKeeper payment, that payment will be a complete subsidy for the wage for that employee, and so your net balance or your net outlay for that employee on notional unpaid leave would still be zero. So that's that question. I see we're over midday, so I think we might leave it there if I may. But again, on behalf of Stephen and myself, thank you for taking the time to listen to our presentation today. I hope it was valuable and you got some insight as to how to weather the storm that we're currently all in the middle of. And on behalf of Stephen and I, all the best for the days, weeks and months ahead, and stay safe. Thank you.